More now on the allegations surrounding Sir Philip Green, with the billionaire businessman firmly denying claims of sexual harassment and racist abuse. Let's get the views of employment lawyer Matt Gingell. He joins us live from West London this hour. Matt, great to have you on the programme. And the war of words continues. We've just heard from Lord Hayne saying he stands resolutely by what he did on Thursday by breaking parliamentary privilege. On the other hand, Sir Philip Green says it's outrageous. Whose side are you on?
I'm on Philip Green's side on this one. I think that it was wrong and unfair for Lord Hayne to use parliamentary privilege and out him as he did. I think that it was wrong. The Court of Appeal had issued an interim injunction, and I don't think that it was appropriate for his name to be outed. The allegations against him had not been proven in court, and he denied any wrongdoing. And there was a confidentiality agreement that had been entered into.
Right, but what about in the public interest? I mean, look at how much headline space this story has had in the last 48 hours. It's hard to argue that it isn't in the public interest, isn't it?
Well, I think you have to be very careful, because it's a question of where do you draw the line. There was a confidential agreement, and parties had entered into that. And if you do start to decide that you're going to allow people to breach confidentiality, it's going to have some big repercussions. People are going to have much more difficulty in entering into settlements. And this isn't going to be in people's interests, particularly people who are bringing allegations of harassment and want those matters settled. Employers are not going to be very keen to settle if they aren't going to be able to have confidentiality. There's going to be very little incentive for them to settle.
Right, well, let's talk about NDAs in a bit more detail, because that is at the heart of this story. Remember, it's also very important to say throughout the whole of this conversation that Sir Philip Green denies all these allegations. Just remind us very briefly and in layman terms what a non-disclosure agreement is.
A non-disclosure agreement, which could also be named as a settlement agreement, is an agreement whereby the parties enter into an agreement where normally, for example, an employer would make a payment on the basis that the employee doesn't bring any claims, or the ex-employee doesn't bring any claims. And it would be usual under these agreements to have a confidentiality clause whereby the individual has to keep those terms confidential. It's important to say, though, that there are some exclusions. And one of the exclusions is whistleblowing. So an NDA or a settlement agreement can't exclude whistleblowing, reporting wrongdoing. And likewise, it can't exclude reporting matters to the police. So there are already some safeguards.
Yeah, NDAs were designed or are designed to protect commercial and sensitive issues. I mean, I'm sure I've certainly signed quite a few throughout my working lifetime. I mean, they're not designed to cover up illegal behaviour. And let's face it, sexual harassment and racial abuse is illegal behaviour.
Well, you have to be careful, because there are obviously going to be allegations from time to time raised by people, but these allegations aren't proven until a court has made a determination on them. And there are a number of situations where employers will make payments to people because they don't want to go through the rigours of an expensive court process, and that doesn't necessarily mean there's fault on the employer's part.
It looks bad, though, doesn't it? It looks like hush money.
Well, I think you have to be very careful, because, as I said, where do you draw the line? You can't really have one rule for one person and another rule for another. And in a way, you've got to think about, whether people are going to be able to, to settle matters if they wish to. I think
Theresa May alluded to the fact this week, actually, in PMQs, that there needs to be reform of these NDAs, so employees realise their rights. Would you agree that this area needs to be tightened up?
No, I don't think so. I think it's a knee-jerk reaction to what's happened. And I think you have to be very careful. You have to look at the legal perimeters very carefully before you decide to take measures which I think in the long run are going to have adverse consequences. I think there's another issue here, which is that actually we've also got to have a look at access to legal justice, because if the cases are very difficult to bring, expensive and complicated, and take a long time to reach tribunal, that's another problem, which if that could be addressed, then people may decide that they don't want to enter into these agreements and wish to continue in court. But if access to justice is not easy and complicated, then that's a problem.
So access to justice, everyone would agree with, everyone deserves their time in court. What about the issue of, if you've got money, you can afford legal protection? Is that fair?
Well, I think that you've got to. There has got to obviously be consideration about the costs in bringing claims, and of course, often employers will have bigger pockets. But I think that doesn't mean that we've got to take a knee-jerk reaction in terms of these agreements, where many employees don't want the hassle of going to court. They don't want a long, drawn-out, stressful experience. And if you start banning confidentiality clauses, then employers are just not going to have that incentive to reach agreements.
We'll leave it there. Employment lawyer Matt Gingell, thank you very much for your time.
Okay.